When a clause in a contract is silent on when an act or obligation has to be performed by, courts will generally imply in a term that it has to be done within a reasonable time. The Court of Appeal has recently handed down a decision to provide some guidance on what a reasonable time means in this context. The name of the decision is Donau Pty Ltd and ASC AWD Shipbuilder Pty Ltd. My name is Luke Dominish and I'm an associate in the Litigation and Dispute Resolution Group at McCabe Curwood. Today I'll be going to update you on the matter of Donau and ASC AWD Shipbuilder, which we recently represented Donau to a successful appeal before the Court of Appeal. The matter arose out of a dispute concerning the construction of 3 Hobart-class air warfare destroyers for the Royal Australian Navy. The ships were to be constructed by ASC AWD Shipbuilder Pty Ltd, a company established by the Commonwealth of Australia. ASC then entered into various subcontracts with other parties to build various different parts or blocks for the ships. One party was Newcastle-based shipbuilder Forjax, who was subsequently renamed to Donau. Forjax and ASC entered into a contract back in 2009 to build various blocks. The contract provided for what blocks were to be built, along with the formula for calculating the fees for which Forjax would be entitled to. Fees were tied to the project's performance, so if there were delays, the fees would be decreased. The project was fraught with complications and delays, some of which were completely outside of the control of either party. It became impossible for the parties to use the formula under the original contract to calculate the fee entitlement. In order to remedy this, in October 2012, ASC and Forjax entered into a new contract, referred to throughout the proceedings as the Second Heads of Agreement, which provided for a new mechanism for calculating fees. It also contained various clauses that required the parties to re-baseline the performance metrics for the contract. This included both budget and schedule. ASC held an express unilateral right to terminate the Second Heads of Agreement, but the clause in question was silent as to when this right had to be exercised by. The parties attempted to reach agreement on re-baseline, but were unable to do so, and accordingly in June 2013, ASC purported to terminate the Second Heads of Agreement. A dispute arose as to what the correct fee entitlement was, which led to proceedings being commenced in the Supreme Court of New South Wales. The parties were tens of millions of dollars apart in their calculation of fee entitlement. One of the key questions was whether the fee calculation mechanism under the Second Heads of Agreement was to be applied. ASC submitted that the new clauses of the new contract never came into effect as the re-baseline was not agreed, and that in any event, ASC had terminated in June 2013. At first instance, Justice Ball found that despite failing to reach agreement on the re-baseline, the relevant clauses of the new contract had transitioned in February 2013, and it was at this time that ASC's right to terminate had accrued. His Honour agreed that a requirement for ASC to exercise this right within a reasonable time was to be implied into the contract. His Honour also found that ASC had terminated in June 2013 and that this was within a reasonable time. His Honour's decision was subject to an appeal by Forjax and a cross-appeal by ASC. The Court of Appeal was unanimous in its conclusion that the date of transition to the new contract was December 2012 and not February 2013, and that ASC had not exercised its right to terminate within a reasonable time. However, the court differed as to the method of reaching its conclusion on reasonable time. President Bell, with whom Acting Justice of Appeal Emmett agreed, took the approach of implying in a term. The President concluded the legal meaning of reasonable time must be determined as at the date of the contract, but the factual question of whether a reasonable time had passed had to be considered at the time the right accrues. That is, you are not to take into account facts after the right accrues. His Honour found that a reasonable time had expired, but because by June 2013, the parties had been operating under the Second Heads of Agreement for many months. There was a need to terminate quickly, as over time it became more difficult to revert back to the original contract, and that if they were not going to terminate, it was open to ASC to negotiate a standstill agreement or reserve its rights. ASC did neither. Accordingly, the President found that ASC's purported termination of the Second Heads of Agreement in June 2013 was not effective. Justice of Appeal Baston, however, took a different approach, which did not involve implying in a term that the right to terminate had to be exercised within a reasonable time. His approach was to interpret the clauses of a contract in such a way that required the exercise of the right to terminate within a reasonable time, confining his consideration of the contents of the new contract itself. President Bell's approach forms the majority of the Court of Appeal in this case, and time will tell if the different approach used by Justice of Appeal Basson will get further support. McCabe Curwood acted for Forjax throughout the dispute with ASC, including at first instance before the Supreme Court of New South Wales and before the Court of Appeal. To find out more about the different approaches and the case in general, see our recent articles on our website. Our litigation and dispute resolution group has experience in advising its clients and acting for them in large contractual and commercial disputes, including at trial and at the appellant level.